All right. So I get a lot of questions about moving out of the family residence either before or after a divorce action. And does that mean that you've given up all rights to the house? Well, let's talk about what does all rights to the house mean, okay? If you have moved out of the house, does that mean that the house can't be ordered sold, or you can't do a division where you are getting some sort of an offset based on the value of the home? Absolutely not. It does not mean that. Does it mean that you are likely not to receive that asset if that is something that you want? Yes, that is accurate. Okay, it doesn't, that is not a fast and hard rule. It does not mean that that is an absolute. It does not mean that that can't happen, but it is likely not to happen. And here's the other thing to remember. The general rule that we will find is if you have minor kids, okay, so if you've got child custody issues and the person who is going to be the joint managing conservator who can establish who has the exclusive right to establish the primary domicile of the child, or if you have one who is a sole managing conservator, that person is typically going to stay in the house with the kids. Now, at the end of the divorce action, does that mean that the house can't be sold? No, it absolutely does not mean that. Okay, it depends on if the person who is in the house with the kids has the ability to actually afford the house going forward. Because if that person does not, most likely what's going to be ordered is that house is going to be ordered to be sold, and the proceeds from it are going to be ordered to be split between the parties in some fashion, not necessarily 50-50, but in some fashion, depending on the division of the other assets.